So we'll start with Negotiable Instruments Act of 1881. Though the act is structurally little difficult because of the wordings used in the law, because this is one of the very oldest law, 18th century law. So the construction of this law is from slightly different language. So it is based on 18th century English. So it was slightly difficult from that perspective, and also as well as you get the information that from the predecessors, NI Act padikadara uttra choice la. So generally there is an advice so that with that carry forward effect we approach this law, therefore it is difficult. But generally it's a very easy law, pretty easy law. It's basically a law of common sense, right? So let us quickly get into some basics. First, what we call it as an instrument. Please respond. What is called as an instrument? Yes, fantastic. Instrument is nothing but a document in writing, giving the holder thereof right to receive money in the context of the negotiable instruments. What is called as negotiable? Negotiable is nothing but transferable. Transferable by delivery or by way of endorsement and delivery. Transferable simple delivery or way of endorsement and delivery, simple. Now what is negotiable instrument? Simple. So it's a document in writing which is transferable by delivery or way of endorsement delivery and gives the holder thereof a right to receive money. So which is these two put together you are required to just combine here. Simple. That is negotiable instrument. But Negotiable Instruments Act defines the term NI as follows. It gives an inclusive definition. As NI means and includes the following. What are basically considered as the negotiable instruments? Bills of exchange, promissory note, check. Which are either payable to the bearer or payable to the order. Simple. So negotiable instrument means and includes the following: bill of exchange, promissory note, check payable to the bearer or order. But not only these are considered as negotiable instrument, any other instrument which does a similar thing could also be considered as a negotiable instrument. So therefore it is, what is more important is the character of the instrument, by which capable of giving the holder thereof a right to collect the money, and which could be transferable and by means of either a simple delivery or by you write on the back side of the instrument. It's called endorsement, writing on the back side of the instrument, giving a direction for payment and making a delivery. Endorsement and delivery, or make a simple delivery in case of a blank instrument. Let's take first an example of bill of exchange. Example of a bill of exchange. Let's assume A sells goods to B for ₹1 lakh. So B is required to pay 1 lakh rupees to A. Now what B can do? B can pay it in the form of cash, gives a check after utilizing the credit period, or they agree to settle by way of drawing a bill. You want to draw a bill and settle this. Let's assume A draws a bills of exchange for the purpose of settlement. So A draws a bill of exchange on B. B owes money to A. So for rupees 1 lakh, A is called as what? Drawer. B is called drawee. So the drawer of the bill, who has a authority to collect money. In case of bill of exchange, a drawer is a person who has authority to collect money. That is very important because as distinguish that from the promissory note. Promissory note is written by whom? Promissory note is written by a maker who has an obligation to pay money. I borrow money of 1 lakh rupees from you. I write a promissory note. I promise to pay a sum of rupees 1 lakh to the bearer to the order. Which means it is drawn by a person who has obligation to pay. But bill of exchange is drawn by a person who has authority to collect money. That is Mr. A here. So drawer of the instrument, drawing the instrument on B. Now B, what he has to do? He has to accept the bill and sends it back to A after acceptance. So he has to accept and send it back the bill. How B will accept the bill? So he has to say I accept and put a signature, or at least merely put his signature on the bill, on the face of the bill or on the back of the bill, and send it back to A. Actually, in olden days, if you find, A will be from India, B is in England. A draws a bill upon B, England sends to him. It will take some months to reach him. Thereafter, B has to sign the bill and send it back to A. It again takes some months to reach A. Then A becomes a proper holder of the bill when it comes to A, because which means in a bill of exchange, the holder of the bill will be the drawer. The drawer becomes a holder of the bill moment it reaches him. Correct. So that is why, because in the olden days they said that acceptance includes even a notice of acceptance. So the moment B signs and puts it in the course of transmission, it has to come through ship, and immediately through a telegram or through a phone he informs A that I already accepted. It is coming in the course of transmission. There ends the acceptance. No physical reach of the information or the particular instrument to reach A is required. Acceptance includes a notice of acceptance also. There is an explanation in the section. It says acceptance includes a notice of acceptance, keeping this particular difficulty in view, because the understanding of this particular act is required, keeping in view how the transactions have actually been settled in 18th century. This is the mode by which settlement happens. So now A become the proper holder of the instrument. Now what is the right available to A? Primarily, what is the right available to A? A has three options. Option 1, he can go to the bank, discount the bill, get the payment. Option 1. Option 2, retain the bill till maturity. B agrees to make the payment after 3 months. After 3 months, A takes the bill to B, present the bill, collect the payment. C. Option 3, endorse the bill. Let's assume A endorses the bill to C. A endorses the bill to C. C is called as endorsee. You can either call as endorsee or endorsee. Both are one and the same. So this is, one is US English, another is UK English. That's it. Both are one and the same. Great. A was the holder, primary the drawer, then the holder, now has become the endorser. Because one who negotiates the instrument is the endorser, and to whom it is negotiated is the endorsee. Now why should A endorse the instrument to C? Primarily, why should A endorse the instrument to C? A owes some amount to C. Technically, C is a creditor, which means I owe some amount. Instead of repaying 1 lakh rupees in cash, I give you bill worth 1 lakh rupees, which either again you can further negotiate or go to the bank, discount it, or wait till the maturity, take the instrument to B makes the payment. A bill of exchange could either be drawn in such a fashion there can only be two parties, or originally when A draws the bill on B, he can straight away draw and give an instruction that you make the payment to C. In which case A will be the drawer, B will be the drawee, C will be the payee of the bill, who is a beneficiary. In the given case, when A is drawn a bill on B in which B accepts to make the payment only to A itself, A is both a drawer and payee. So in a bill of exchange there could be three parties where the drawer and payee are two different persons. They could also be same person, in which case there will be two parties to an instrument. Now let's assume further that C endorses the instrument to D, in which case C becomes the endorser, D becomes the endorsee. D endorses the instrument to E. It goes on. E endorses the instrument to F. And on and on. So which means C endorses here. T endorses the instrument to E. And E endorses the instrument to F. Now what will happen? On the maturity date, what will happen? F goes to B. This is called presentment. Presentment for payment. F goes to B, makes the presentment. What B has to do? Whether B knows F? Whether B knows F? No. He just goes with the bill. So what B can do? We can say, who are you? Show the bill presented. B can verify on the back side of the bill. There will be a log which will be available. What log? That A has transferred the instrument to B, so that C. That C then has further endorsed the instrument to D. Then D then further endorsed the instrument to E. And E then further endorsed the instrument to F. This log is available. Any number of transfer can be made on the back side of the instrument. Even if the space is exhausted, you can use an additional sheet called as what? Even if the back side the space is exhausted, you can still use an additional legal sheet called as a launch, where the endorsement process can still continue. You can write it on the launch, and next to that further it goes from F to G, G to H, it goes on. Any number of transfer is permissible. Now on the date of maturity, F, who is called as the last endorsee holder of the instrument. So before maturity, or rather upon maturity, this guy F goes to B, makes the presentment. B has to honor the commitment. In case B makes the payment, what will happen? In case B makes the payment, there are two possibilities, Leah. There are two possibilities broadly. One, upon the claim is made, there are two possibilities B can. One, B makes the payment. If B makes the payment, what will happen? If B makes a default, what will happen? If B makes a payment, contract comes to an end. Every parties are discharged from the contract. If moment B is discharged by F, C, E, D, C, A, all parties are discharged from the instrument, is also called as discharge of instrument. Discharge of instrument. If supposing B makes a default, what will happen? The act. If he makes a performance, there is no further provision in the act at all. If B makes a default, then what will be the consequence? You will say that instrument has become, instrument has become dishonor. dishonor of the instrument, and you are required to proceed into Panchayat. Protect the interests of the parties. What remedy F has got now? Upon dishonor of the instrument, what remedy F has got? F can sue E, his prior party. E can sue D. D can sue C. C can sue A. A can sue B. Can F directly sue B? Yes, he can sue. Yeah, that's called as, even though there was no privity of contract between B and F, but there was a contract which was executed only between A and B. Because what does the doctrine of privity says? Only parties to the contract can sue. Doctrine of privity to the contract. But now F and B is not a party to the contract. But still F can sue B. That was the right given to F, who has received the instrument in good faith. So F is called as, the way is called as a holder in due course. So you need to understand the following. One who could encash the instrument in his own name and he has acquired the instrument in good faith for a consideration, and you need to check whether he has acquired it before or after maturity. Following are the critical test. First, to be a holder, it is sufficient if you could capable of encashing the instrument in your own name. Not necessary there must be good faith, not necessary there is any consideration, and not necessary that you should have acquired the instrument before maturity. You are a holder. I have a blank check. I sign it. I left it here. He takes it, he goes to the banker. Can he encash the instrument? Yes. It's a blank check. No, not crossed. It's a bearer instrument. So the bank could make the payment to anybody who comes with a check. He is not a true owner of the check. He just found the instrument on the road, picked it up. But can he encash the instrument in his own name? Yes. He is a holder of the instrument. So holder means not a person who is possessing the instrument is a holder. He should be capable of encashing or liquidating the instrument in their own name. He picked the instrument, but it was an account payee instrument. His name and the check name doesn't tally. You cannot encash the instrument in your own name. You are not a holder of the instrument. Now, holder for value. What is called as a holder for value? He could encash the instrument in his own name. Whether there is good faith or before maturity doesn't matter. But he has acquired it for a consideration. I issued a check to him because I borrowed money from him. I repaid it. I purchased goods from him. I repaid it. I issued a check for a consideration. The third thing is holder in due course. Who's that? You could encash the instrument in his own name. You acquired it in good faith for a consideration before maturity. Instrument has a maturity date. What is the maturity date? It depends upon the tenor which is agreed to by the parties. In case of demand instruments, any time it could be demanded for payment. In case of time instruments, upon happening of or upon expiry of that particular time as agreed with the parties, the instrument could expire. And upon that particular expiry time, they could proceed and then present the instrument and demand the amount for payment. So, holder in due course is a person who is entitled for payment in his own name, because primarily he is a holder, plus he acquired the instrument for good faith, for consideration before maturity. So generally, unless otherwise this presumption is broken, always you assume that the party is a holder in due course. The holder is always assumed to be a holder in due course. In case it is otherwise, then you have to prove that I issued a check to him as a gift for him. He is not a holder in due course. It is not issued for consideration. Then court will generally presume that he is a holder in due course, the donee is a holder in due course. In case I wanted to prove him that he is not a holder in due course, it is my responsibility to take to the court and say that I issued a check not for clearing any liability, there is no consideration, he is not a holder in due course. I have to prove. So onus of responsibility lies on the person who have drawn the instrument, the drawer, to prove that the person is not a holder in due course. So now on the maturity date, F goes to B, makes the presentment for demanding the payment. B makes a default. F, one, notwithstanding the fact that he has no privity of contract with B, can sue B. In his own name he can sue. F can file a suit for default of B in his own name. And he can also make, please note, not only the immediate prior party, to a holder in due course, it's like a contract of guarantee. All these persons stand as a joint guarantor for F. All these persons stand as a joint guarantor for F, which means F is like a debtor who has an authority to collect money, like a creditor who has an authority to collect money. P is the principal debtor. All these persons stand as a guarantor. It's like it's a contract of guarantee within this. So on the maturity date, F creditor goes and demands money from B debtor. If B fails, all these guarantors could be held jointly and severally liable. That is the privilege given to a holder in due course. That's a privilege given to a holder in due course. The Act gives certain privileges to a holder in due course. Notwithstanding the doctrine of privity, he can sue the defaulter, drawee in his own name upon default for payment. And where the person who is primarily liable, B, fails, I could make any of the prior party liable. Any of this prior party could be held liable. All of them standing in their joint and several liability position for me to honor the commitment. Let's add some reasoning to this. Let's assume that A has endorsed the instrument to C. C has a good title to the instrument. D transfers the instrument. D also has good title. E has stolen the instrument from D. இவர் வந்து கெட்டவர். E has stolen the instrument. Villain introduction. Now F receives the instrument. E owes some amount to F. So he has stolen the instrument. He passes on this instrument to F by writing on the back side of the instrument, paid to F and so on, or to his order. F receives the instrument in good faith. He receives the instrument in good faith for a consideration because he owes an amount to F. To square up that particular amount, he receives an instrument before maturity, and thereby he is a holder in due course. On the maturity date, F goes to B, makes the presentment for payment. Can he claim the amount? Can F claim the amount from B? Will the title of F be valid? Will F get a better title here? Because transferor title, E is the transferor. His title is defective. F is a holder in due course, but then he is a transferee. What will be his title? Will he get a good title? Can therefore F sue B? F gets a good title. What is the general rule of law under Sale of Goods Act? No person can pass on a title better than he has. Correct? Transferee's title equal to transferor's title, generally. Negotiable Instrument Act is an exception to the general rule. Transferee gets a better title than transferor. So F gets better title, which means holder in due course is a superhero of negotiable instruments. Hero introduction. So F is a holder in due course, notwithstanding the defective title of E. F gets a better title to an instrument. So on the date of maturity, F goes to B, asks for the payment. B comes to know about the defective title of E and transfer of the instrument. So when F goes to B, B slaps him and says, "You have a defective title, how can you demand the payment?" What F can say? Slap him back and say, "I am a holder in due course. Notwithstanding the defective title of E, I always get a better title." So therefore, a holder in due course always get a better title of the instrument. There are certain privileges given to him. The first privilege is better title, irrespective of the defective title of the transferor, provided I acquired it in good faith, valuable consideration before maturity of the instrument. I have a better title, I can go and make B liable and claim the amount. Let's assume that D has stolen the instrument. E has, then D transfers the instrument to E. He gets a good title. Let's say he is also a holder in due course because he gets the instrument in good faith for a valuable consideration before maturity. F gets the instrument from E. He acquired it for a consideration before maturity, but he is aware about the defective title of D. He is aware about the defective title of D. On the due date, now F goes to B, presents the bill for payment. On the due date, F goes, present the bill for payment. Can he claim good title and therefore the payment? Is the title of F, because he is aware that title of the instrument is bad as originated originally. Will F get a good title? Whether F get a good title? F gets a good title. Why? He gets the title from holder in due course. So F, you can keep it as a hero in introduction. Any person who gets the instrument from E or rather a holder in due course also gets a better title, because if you insult F, is as good as insulting E. Or moment the instrument passes through E, who is a holder in due course, all defects are said to be cured. All defects are purged, or you can say all defects are cured. It's like Ganga Batmari. Once the instrument passes through E, all defects automatically cured, and any subsequent person who receives the instrument also gets a good title. And therefore, F gets a good title and he can sue B. So what are the quick presumptions which can be derived here? 1. Instrument can be transferred any number of times. 2. It can be transferred until the payment is effected by the person who is primarily liable on the instrument. See, on the due date, if supposing B makes a default, still F can endorse the instrument to G. But only thing is, G will not be a holder in due course. He can only be a holder for value, because he receives the instrument after maturity. Instrument can be transferred even after maturity also, but then the holder will not be a holder in due course. Get the point? He will be a holder for value, not a holder in due course. So first point is to remember who is a holder in due course. Second is to quickly remember what are all the privileges of holder in due course. What are also the quick privileges of a holder in due course? Very important. One is title. Rather than saying title, better title. You always get a better title than transferor. Transferee's title, being a holder in due course, is better title than transferor. Then defects, purged from all defects, which means any person who is getting the instrument from a holder in due course also gets a better title to an instrument. 2. 3 is what? No person can deny the validity of instrument. No person can deny the validity of the instrument against holder in due course. No person can deny the validity of the instrument against holder in due course, which means, let's assume that even A has endorsed A has drawn the instrument on B using coercion and undue influence. A places a pistol on B and says, make the signature. A transfers the instrument to C, C to D. Let's say all of them have got good title to the instrument. Finally, it reaches last endorsee holder who goes to B. Now, B cannot say, my acceptance was coercion, undue influence. No, B has to make the payment because the person who are asking is a superhero, holder in due course. No person can deny the original validity of the instrument. Or A originally draws the instrument, which means no consideration. When there is a coercion, there is no consideration. Which means A cannot sue B. But on the basis of this instrument, thinking that it is 1 lakh rupees worth of instrument, C took the instrument in good faith. A settled his loan to C by transferring this instrument. C settled his loan to D by transferring this instrument. D to E, E to F. Therefore, these obligations have been cleared there. So, I received for a value for the loss of money which I have done. So, therefore, I can sue B. Notwithstanding the fact that there is no consideration in the original validity. So, nobody can question the original validity of the instrument. Further, prior parties could be held liable. And in fact, all prior parties could be held liable. Upon the failure of the instrument by the person who is primarily liable on the instrument, every prior party could be held liable on the instrument. All prior parties could be made liable to a holder in due course. Even if D has stolen, at that time he cannot, no person can deny the validity of the instrument. At that time, D cannot say, come on, I have only stolen the instrument. How can he make me liable? He can be held liable in case he could be traced. Or otherwise, make the C liable. Because all parties are jointly and severally liable to a holder in due course. Liable. He can make prior also liable. Jointly and several liability of all person. If D is not, he cannot make D liable, he could make C liable. That is what joint and several liability. To holder in due course. Every prior party is jointly and several, like a joint guarantor for the debt to marry. That is the wide understanding required.
C has stolen the instrument from A. That time when A asked for B to give it back to that
C has stolen the instrument. So that depends on whether B has made the payment or not. If B has already made the payment, then why should again make the payment to A? Not made the payment, then he can instruct B accordingly, and he can, similar to cancellation of check, he can countermand the payment, considering fraud. But if B has already, he can draw a new bill after giving an advertisement in the newspaper. In case supposing B has already made the payment, B, the point is, please note B is not at a loss. The loss is with the drawer. Because I am required to make the payment to any person who comes with the instrument. That is the commitment which I have given. That is the purpose of negotiable instrument at all. Facilitate innumerable transfer. And it is also a simple way by which the entire mutual loan comes to an end. Instead of B paying 1 lakh rupees to A and A taking this physically 1 lakh rupees to C and taking this, paying this loan, then C putting it to, issuing a check to D. இவ்வளோ நாள் ஆகும் செக் கிளியர் பண்ணி வர ஒருத்தனா லோன் அடிச்சுட்டு வரணும்னா இன்ஸ்டெட் ட்ரா எ பில் எல்லாரும் மியூச்சுவலாக 1 lakh அவுட்ஸ்டாண்டிங்னா ட்ரா எ பில் ஆன் பி ஜஸ்ட் ட்ரான்ஸ்ஃபர் பை வே ஆஃப் அ சிம்பிள் சிக்னேச்சர் on the final day F could collect the payment from B, all the parties loan could straight away be settled. So innumerable transfer is also being facilitated. No person can tell me evaluate original validity of the instrument. All prior parties could be made liable. So even if the consent, there is no consideration originally when the bill is drawn, holder and due should receive the bill only for a consideration. Or 6, it's drawn for unlawful means. It is drawn by way of some unlawful means, that is coercion, undue influence, etc. Still the holder in due course has a valid right to recover. Lastly, he can sue in his own name, notwithstanding the doctrine of privity. Upon default, he can sue in his own name. There is one more special right given to him, is in case of inquiet instrument. Inquiet instruments are also called as inadequately stamped instruments. Inadequately, just made some small shortcut for the spelling. It's not a spelling mistake, right? So inadequately stamped instruments or inquiet instruments. Inadequately stamped instruments. Yeah, what is that inadequate stamped instruments? See, as per the law in force, bill is required to be stamped based on the value. See, in olden days, the stamp goes to 1 page, 2 page, 3 page stamp, etc. 1.5, 2.5 stamps, etc. Now the maximum stamp you are required to put is 1 rupee only, not more than that. But for example's sake, let's take some 10 or 20 rupees. Let's take that for a 1 lakh rupees, you need to affix a 10 rupee stamp. What will happen is, instead of considering this 18th century transaction, every time A has to draw a bill, send to B, accepted, and he has to send it back. It involves a huge time consuming process. So what they generally do is, A will have certain bill in which every details gets filled in. Drawee's name, his signature will be available, date will be available, stamp is also affixed. Only thing will not be there is amount. That's called inadequately stamped instruments, or also called as blank instruments. So in that case, blank instruments, inquiet or blank instruments. In that case, what happens is A affects a sale to B for a bill of 1 lakh rupees. With the consent of B, he will just put 1 lakh rupees right on the instrument, encash the instrument. It's like something like his checkbook, pre-signed checkbook in my name. As and when I deliver the goods, I fill the amount and then send it to the bank. Supposing where, let's assume that there is a transaction value for 80,000. But though 10 rupees, an instrument bears a 10 rupees stamp which is worth 1 lakh, A has sold the goods to B only for 80,000, which means A has a right to recover only 80,000, B is liable to pay only 80,000. But A is having an instrument which is stamped up to 10 rupees, by which I can fill a maximum value of 1 lakh, which is already signed and delivered by B. So instead of filling 80,000, now A, let's assume that he puts 1 lakh rupees. So he draws a bill for 1 lakh which gets transferred to C, C to D, and the last NRC holder, let's assume that he has a bill for 1 lakh rupees. F has a bill for 1 lakh rupees. So on the due date, F goes to B, presents the bill for payment. B gets shocked. I am liable only for 80,000, but then you are presenting a bill for 1 lakh. Can F recover the entire 1 lakh from B? Can F recover the entire 1 lakh from B? Yes. Because F is a holder in due course. He's a superhero, already solliyachi. He is a holder in due course of the instrument because F has got this instrument, good faith, correct consideration. E has 1 lakh rupees outstanding to F. Instead of that, only this instrument has come into him. So F can sue B and recover the entire 1 lakh and not merely 80,000, but then B then has a right to sue A and then recover the balance 20,000 on the grounds, legal grounds. But the stamp that is nothing but the stampage value of the instrument. But supposing, let's assume that I am not a holder in due course. F is not a holder in due course. I am merely a holder for value. I could recover from B only 80,000. Every person can make the last NRC, the person who is primarily liable on the holder, that is the drawee, could be held liable only for the transaction value, except a holder in due course who could make liable for the entire stampage value or the bill value, not only merely the transaction value. This is a liability arises in case of inadequately stamped instruments. Now let's assume that I can put only 1 lakh rupees for a stamp affixed is 10 rupees. I can maximum put 1 lakh. The transaction value is 80,000. But A has written as 2 lakhs. In good faith, it goes to C. In good faith, it goes to D. And last to F. Now F goes to B and asks for the money. Can he recover the entire 2 lakhs? Even if you are a holder in due course, you can recover only 1 lakh. Because no person can recover beyond the stampage value. So in case a bill is not adequately stamped, it will suffer from legal validity. Court will enforce only up to the stampage value, not beyond that. In case you are a holder in due course, there are 3 values to the bill. One is stampage value, another is the bill value, next is the transaction value. Bill value cannot go beyond stampage value. Bill value should always be less than or equal to stampage value of the instruments. No person can make sue the liability and recover the amount beyond the stampage value of the instruments. So in case of inadequately stamped or inadequate stamped instruments, what is the benefit to a holder in due course? He can claim the full amount or not merely the transaction value. But any other person can claim from B only, the given case who is a drawee, only the transaction value. The entire law is for the purpose of protection of holder in due course, for the purpose of offering better protection to the holder in due course. As simple as that. So, coming back to the next segment, different types of negotiable instrument. There are different ways in which the types could be classified. One is called as demand versus time instruments. Demand versus time instrument. What is called demand instrument? What is time instrument? Instrument which is payable on demand is a demand instrument. Correct. Or to other ways put, an instrument on which no time is mentioned. That is easier. An instrument on which no time is mentioned is a demand instrument. P, or it is specifically referred as demand instrument, or it says payment is required to be made at sight. Bill paatha udane pay pananum. It's as good as demand instruments or apportionment. Where the payment has to be made. So an instrument can be called as a demand instrument if no time is mentioned, or if it is specifically drawn payable upon demand at sight or at present or on present. Right. So when you call then an instrument as a time instrument, time is mentioned. Time is mentioned for payment. How time will be mentioned? How time will be mentioned? After a specified period. A bill is payable 3 months after date. 3 months after sight, after acceptance of the bill. 3 months after date na date of drawing. 3 months after sight na A bill B ku anuppuraru, B sign pannadhilendhu 3 months after acceptance, that sight of bill. After a specified period or upon happening of an event which is certain to happen. A draws a bill on B which says, I will make the payment within 3 months from date of marriage of C. A draws a bill on B. It says, I will make the payment within 3 months from the date of death of C. Event is certain to happen. The code even said death is certain to happen. So if it is drawn on an event which is certain to happen, yes, the answer is yes, it's a valid instrument. Otherwise it is not a valid instrument. So time is mentioned, which is mentioned as follows. Time is mentioned in any of the following way: after a specified period, upon happening of an event which is certain to happen, or on a specified day. I draw a bill today agreeing for payment 6th of June 2014 on a specified day. Sufficient compliance. And bill generally becomes a sort of maturity. Bill generally becomes mature for payment a bill generally becomes matured for payment after adding 3 days of grace. This becomes matured for payment after 3 days of grace. In all these circumstances, you need to add 3 days of grace, but not here, where the bill is payable on demand or at time at sight. It becomes immediately for liable for payment and no 3 days of grace. This is called demand versus time instrument. Then second classification is bearer versus order instrument. When an instrument is called as bearer instrument, when an instrument is called as order instrument. Two? Person is specified, person is not specified. Okay. Could be yes, could be no. If the person name is specified, still it could be a bearer instrument. So name is not a criteria. He could still draw a check, pay to Kumar or to his bearer. Then what is the parameter which will classify an instrument as bearer or order? It's nothing but the usage of the word bearer or order, forming part of your tenor. If the instrument tenor specifically says bearer, it's a bearer instrument. If the instrument tenor specifically says is an order, it's an order instrument. Don't have any difficulty in explanation. Name, mentioned, name not mentioned. No. I have a tenor which says paid to A or bearer. Bearer instrument. Paid to A or order. An order instrument. The way in which the payment could be effected will differ. Which means when I say pay to A or bearer, it means pay to A or even any person who comes with the instrument, make the payment. When I say but pay to A or order, pay to A or to the person who A orders by way of endorsement. I say pay to A only. Yeah. It's a bearer or order. I say just pay to A only. I draw an instrument by which I say pay to A only. What happens? It is not a negotiable instrument at all. Because it restricts the very character of an instrument of negotiability or transferability. So therefore, necessarily, recall your definition. What is negotiable instrument? Instrument means it includes the following: bill of exchange, promise or check payable to the bearer or order. Not a negotiable instrument all here. But I simply say pay to A, then what will happen? I simply say pay to A. Bearer or order? Order instrument. Because direction for payment is available and does not prohibit further negotiation. By using the word only in the previous case, you have prohibited further negotiation. Hold is an order instrument. It's automatic. The holder can insert the word or order or bearer. The holder can insert that. That's it. It does not prohibit further. If you have used the word only and you score out the payee scores out the word only, then it amounts to material alteration. So therefore, what is bearer instrument can be explained in the following way. What is bearer instrument? One, instrument expressly mentioned it as order. Tenorla ஐயா ஆர்டர்னு இருக்கு, அது ஆர்டர் இன்ஸ்ட்ருமெண்ட். சிம்பிள். Expressly mentioned it as, here bearer. Expressly mentioned it as order instrument. What is bearer instrument? The tenor expressly says pay A or bearer, pay C or bearer. It was a bearer instrument. What are order instrument? Expressly mentioned it as order instrument. Or, here comes, or instrument is drawn upon a particular person and does not contain what? Does not contain prohibition for further negotiation. Does not contain any prohibition for further negotiation. This is where your example pay A. Particular person, no intention to further prohibit negotiation. What is an example for this? First one, pay A or order. What is the example for this? Pay A or order. A check is always a what? A check is what? It could either be a bearer or order instruments. it's preferable that you strike the word bearer always and make it order, because otherwise any person who could holder of the check could encash the payment unless otherwise it's an account payee check or account payee instrument. So now the third type, these are all very small things. The little explanation it can be easily be understood. The moment this basic you have got very thorough, further reading of the act actually becomes very simple with the background with which we are actually discussing. And last is inland versus foreign instrument. What is inland? What is foreign? Yes. But not necessarily within the boundary only. Sometimes it can, they are told in the olden days, it is necessarily drawn only outside India, only in England only. Drawn by a person resident in India, but paid by a person outside India. The drawer could be a resident, the drawee could be outside India. Therefore, we cannot have an understanding that it is within the boundary. That is not correct. So, what way to understand is, you need to conduct actually two tests. Instead of having this way, you can have this way. You need to actually conduct two tests. First test is, you need to find out whether it is drawn in India, drawn outside India. This is with respect to drawing. Then you need to also find out on whom it is drawn. On whom? Where payment? If it is drawn in India, then ask these questions. These two questions. Drawn in India, on whom? And made payable where? Where payment? If it is drawn outside India, close your eyes, straight away say instrument is foreign instrument. But just because an instrument is drawn in India, it could not be a inland instrument. This is condition 1. In addition to which, it has to satisfy either of these two conditions. Either this or this. On whom, which means drawn in India, upon person resident in India, PRII, person resident in India, or where payment made payable, say in India, it's made payable in India. So which means an instrument can become inland, combining these two, an instrument can become inland under the following two rules. Rule 1, drawn in India and drawn upon a person who is a resident in India. B, the instrument can become inland in case it is drawn in India and made payable in India, even though it could be drawn upon a person resident outside India, but made payable in India. But if it is drawn in India, neither made payable in India, nor it is drawn upon a person resident in India, it straight away becomes a foreign instrument. Even though the instrument is further endorsed outside India, it doesn't matter. Initially as it is drawn. But subsequently when it is endorsed outside India, but though the initial drawing is in India, that is sufficient. Right? An instrument continues to be an inland instrument, though it is endorsed outside India. Because as long as the party is in India, you have to honor the person's ultimate liability, you need to find. That is how it goes. So there are three ways of classifying the instrument. Simple way, going in reverse, inland versus foreign instrument. We saw that. Bearer versus order instrument. Then we have the demand versus time instrument. All these are very important. Check is always a demand instrument. A check is always a demand instrument. Promissory note or bill of exchange could either be demand or time. A check could either be a bearer or order. But promissory note and bill of exchange will always be order only. It cannot be bearer. You cannot draw a bearer promissory note because only RBI can draw a bearer promissory notes. Because bearer promissory notes are nothing but currency notes. Currency notes can be printed only in Nasik. You cannot print currency notes. So therefore, you can draw only order promissory note and order bill of exchange. Section 31 of the RBI Act prohibits drawing of these notes, which are bearer. You can draw only order. And any of these instruments could be an inland versus foreign instrument, technically. This is the next understanding of the entire situation as it is called for. Fine. In case where the instrument is a foreign instrument, the panchayat has to be dealt under the foreign law. What constitutes dishonor? What is the time limit for serving notice of dishonor? In case the instrument is an inland instrument, the panchayat has to be dealt under the Indian law. Check time போட போறியா? ஆமா, check வந்து 3 months validity. ஆமா. Time instruments? ஆமா. No, but any time within, see, you have to understand another point. RBI specifies 3 months. Inside Negotiable Instrument Act, there is no 3 months. RBI said for the better protection of the banker, the check has to be presented for payment within 3 months. That is the time which is given by RBI to the banker. This banker is under obligation to comply with the direction given by RBI. Nowhere inside the Negotiable Instrument Act you find that the validity of the check as 3 months. Previously it was 6 months, now it is 3 months. So as far as the NI Act is concerned, there is no such time limit. Technically, it's only the direction given by the RBI. Secondly, within this period of 3 months, any time I issue a check of 1 lakh rupees to him with my account with, let's say, ICICI Bank, anytime you can go and present the check and get the payment. The banker is under obligation to pay the amount. Banker cannot come and tell him, come after 1 week, come after only the bill comes for maturity. Demand. Moment the instrument presented, banker has to make the payment. So demand instrument. The next segment of the analysis on exploring the NI Act is. So quickly, the next important area to concentrate is bills of exchange. Definition of bills of exchange: promissory note, check. But first, it is better to do the definition of promissory note. Then comes check. So, what is called a promissory note? Section 4, Section 5, Section 6. Yeah, promissory note means what? Yes, it's an instrument in writing containing an unconditional undertaking. Yeah, it is very important. Unconditional undertaking. Then signed by the maker to pay a certain sum of money to the bearer or to the order. But as per the RBI regulation, I told you, bearer is not. Though the definition says yes, As per the RBI regulations, you cannot draw the instrument which is bearer. Only order is permitted. So the definition is very, very exhaustive and it contains all possible things. First of all, it must be in writing. No oral thing can be considered as a promissory note. The condition must be unconditional. There is no any condition attached to it. And it is basically an undertaking, which means it is drawn by a person who has an obligation to pay money. To pay a certain sum of money only. Consideration can only be money. I cannot draw an instrument and then say, I will give you 1000 kg of onion which gets cultivated in my land. So, consider, I give you elephant. It can only be money. Money only can be the considerations. Even if it is partly money, partly other than money is also not valid. Money only is the considerations. That money should be certain sum of money. I draw a promissory note promising to pay 1 lakh rupees plus whatever the money I feel like after 6 months. That's not the right way of doing it. At least it should be capable of making it certain, capable of making it to a fixed sum. Then it is at least valid. I promise to pay 1 lakh rupees plus interest at the rate of 6% for 6 months. You have not committed for an exact amount, but I am capable of computing it. That is a sufficient compliance. Similarly, what is a bill of exchange? Same idea. It's an instrument in writing containing an unconditional order. It's an unconditional order. Instrument in writing containing an unconditional order signed by the maker or drawer to pay a certain sum of money only, duly stamped and all the things to the bearer or to the order. In RBI Act, you can draw only order instruments. What is a check? A check is a bill of exchange. Starting here, a check is a bill of exchange, which means all these has to apply here. It's an unconditional instrument in writing, an unconditional order signed by the maker to pay a certain sum of money only. Everything comes here. A check is a bill of exchange, then drawn upon a specified banker and not expressed to be payable otherwise than on fantastic. Not expressed to be payable otherwise than on demand. A check is a bill of exchange, which means there itself a definition is complete. All the conditions which are applicable for bill of exchange equally applicable for check, with the following 2 exceptions. One, in a check, it is always drawn upon a specified banker, which means drawee in a check. This is nothing but the drawee. Who is the drawer? The account holder of the check is the drawer. Who will be the drawee in a check? Always the banker. If you visualize the process of a check, let's say A is a drawer. A has account with SBI. B is the payee to whom the check is given. B has account with, let's say, ICICI. Let's say some Bank of Baroda, BOB, basically National East Bank. So A issues a check to B. B is the payee. A is the drawer. Who is the drawee? That is the banker of A. The banker of A will be the payee, drawee. This banker is also called as paying banker. This banker is called as collecting banker. Mobile rings. This banker is the banker of the payee, who is also called as the collecting banker. NI Act places a responsibility both for the paying banker as well as for collecting banker. Now, what this particular importance? Drawn upon a specified banker, which means always the drawee is going to be the banker. Secondly, and most importantly, not expressed to be payable unless otherwise the payee goes to deposit or goes to collect the payment. No payment can be done. And a check could be the following. It could either be a account payee check, then it could be crossed or uncrossed check primarily. First of all, it could be a crossed check or uncrossed check. Then rather the crossing could either be account payee or it could be a non-negotiable crossed check. What is a crossed check? Yeah, putting a two transverse lines on the face of the check. Where generally you are required to put this crossing? On the left hand side top corner. Can you put this on the top central portion? Top center. You can put that, not an issue. You can put that, not an issue. Anywhere you can put this. Generally, if you visualize a check, you cannot put it on the bottom because it's a MICR portion. Right hand side top you cannot put it because date irukanga. Left hand or center is also open, you can put it. There nowhere in the law it is said as you have to put it on the left hand side top. It is we generally cross it left hand side. In fact, if you find there are certain checks like Standard Chartered Bank check or HSBC, it comes with pre-crossed printed where it is crossed only at the center. Anywhere you can cross. Customary practice we adopted right from a 12th standard. We give an explanation, drawn on the left hand top corner, two drawn inverse lines. Not necessary. But what does this refers to? What does this refers to? What does crossing refers to? It is nothing but a direction for payment. What payment? Direction for payment given by drawer to paying banker, that is the pay. What direction? Now what does A says to SBI? A issues a crossed check to B. What does that impacts or how does that impact SBI? He tells SBI, don't make the payment across the counter. SBI shall make the payment only to another banker, not directly to B. That is what called crossing. Instead of communicating in a lengthy para and putting an instruction, we adopted to a symbol language. If I put two symbol in the cross, it's a direction given to you that you cannot make the payment directly to pay. B cannot go to SBI, present the check in the counter and then collect it. B has to compulsorily what? Deposit to his account, which let's assume Bank of Baroda. Bank of Baroda has to send it to clearing house for collecting the payment. And Bank of Baroda has to get the funds from SBI. So SBI will then transfer the funds to Bank of Baroda. Bank of Baroda then transfers the funds to B. This or that could again crossing could either be a general crossing or it could be a specific crossing. It could either be a general crossing or a specific crossing. What is general crossing? Just simply two transverse lines, that's all. That is two lines. Whether you put any unco in that or you put simply even account payee, that is also general crossing, or you put non-negotiable simply, that is also general crossing. What is then specific crossing? Name of the banker is added in addition to the above. I draw two transverse lines and put that in addition to the two transfer, in between two addition lines I add account payee Bank of Baroda, which means what is the direction given to, what is the direction given by A to SBI? SBI can transfer the funds only to BOB. Yanagal Pandina, you are liable. Specific direction. So which means a payee should have an account only with Bank of Baroda to claim the amount. Mostly salary checks are account payee specific banker. The employee is expected to have an account with the specific banker to get the cleared payments. So which means B could, in case supposing where account payee specific crossing, A issues a check with the direction that account payee Bank of Baroda. A and goes deposits a check with Canara Bank. If Canara Bank collects the payment and there is some fraud, collecting banker could be held liable. Even paying banker could also be liable because A has directed you to make the payment to BOB, and how dare you can make the payment to Canara Bank. There's a negligence on the part of the banker in making the payment. He could be held liable for the purpose of claiming the payment. Negligence பண்ணக்கூடாது. That is what RBI's direction. பண்ணிட்டானா அவன் liable. True account holder you have to compensate. Something goes wrong. You should not collect. First of all, collecting banker should not send those checks for clearing at all. That is the very purpose. Now comes what is account payee crossing. What is account payee crossing? What will be the effect? Account payee BOB ன்னு சொல்றோம். What is account payee crossing? SB account அதுதான் crossing. அதுதான் two transverse lines. நான் சிம்பிளா two transverse lines போடுறேன். அப்பயுமே what you can do, you have to only have a bank account. In addition to that நான் account payee ன்னு எழுதி தரேன். என்ன ஆகும்? What happens? Account payee Mr. B ன்னு போடுறேன். என்ன ஆகும்? It is a direction not only to SBI, it is a direction also to Bank of Baroda. A gives a direction not only to SBI, A gives a direction also to BOB. What is that? Direction to SBI is you should make the payment to another banker. Direction to BOB, you should credit this proceeds only to account of Mr. B and nobody else. So technically speaking, account payee crossing impacts what? Further negotiability. Technically speaking, we cannot negotiate the instrument further in case it is an account payee crossing, because even if it is negotiated, Bank of Baroda can make the payment only to B. But again, account payee is not a rule under negotiable instrument. It is an instruction given by RBI for better protection, for better safety. These have been given, that these instruments are required to be an account payee. The moment there is an account payee crossing, it gives me a protection that the payment is required to be given only to the particular designated person. Then coming back to non-negotiable crossing, only to the account of the payee. That is the account payee crossing. What is meant by non-negotiable crossing? See, in case there is no negotiation, means it cannot be a negotiable instrument at all. What is non-negotiable crossing? What is non-negotiable crossing? Instrument can be negotiated, but in case it is negotiated, the transferee's title will be same as transferor's title. What is the rule under Negotiable Instrument Act? Supposing, let's assume B will be the holder of the instrument. A issues a check to B, B will be the holder. Payee is the holder of the instrument. B endorses the instrument to C. B ki good title irundadna C ki good title pogum. Supposing then C has stolen the instrument from B. C then again negotiates the instrument to D. C has a bad title. Now C has a bad title here. General rule in if suppose D is a holder in due course, what happens? General rule of negotiable instrument is D gets a better title than C. But in case it's a non-negotiable crossing, D gets the same title as that of C. D also gets bad title. Which means when he gets a bad title, he cannot retain the funds. He has to compensate the funds back to the true owner. He cannot retain the funds. So non-negotiable crossing means, don't apply a grammatical meaning here. It cannot be negotiated. No, it can be negotiated, but if negotiated, what happens? The transferee will get the same title as that of transferor. So last one part we will close this negotiable instrument is section 138, which talks about what? Dishonor of check. Dishonor of check is treated as a criminal offense, where there are instances we find that without having any sufficient balance, A issues a check and he knows that there is no bank balance, and temporarily I wanted to safeguard myself from a creditor. So what I do, I issue a check. It takes a time of 2 to 3 days. Till such time I can aramse settle down. Otherwise the creditor beats me. So then with no funds, the check goes dishonor, bounces back. I can issue another check. After all, the maximum expenses for me is the dishonor charges of 100 rupees. So creditor are pressurizing me, keep on issuing a check. So people started taking banking for a granted. They started playing with banks. It's like a bank games madri. They started playing with banks. They keep on issuing a check, they collect and go ahead and make the payment. So under this particular circumstances, what happened is, where normally any check which is issued for payment, the court will presume that these checks have been issued only for clearing the liability. Once a check is issued for clearing the liability, and if it is returns unpaid for non-availability of funds, it gives a right to the payee, duty casted on the payee. He has to serve a notice of dishonor to the drawer. Check யார் கொடுத்தாங்களோ அவங்களுக்கு நோட்டீஸ் அனுப்புறோம். இதுமாரி நீ கொடுத்த செக் டிசானர் எடுத்து you are required to make the payment within a period of 15 days. So within 30 days he has to send a notice giving a time of 15 days. If within 15 days he makes a payment, fine. If within 15 days he doesn't make the payment, the drawer is deemed to have committed a criminal offense. He could be prosecuted 2 years of imprisonment with twice the amount of the check for a penalty. So what are the conditions if you see for the prosecution action? First condition is check is issued to clear the liability. First condition, check is issued to clear the, in case I issue the check for gift and the check dishonor right, you cannot initiate a 138 action against me. Issued to clear the liability, either full or part liability. And second condition, returned unpaid due to what? Because there may be various reasons for dishonor of check. That is also an important question. Go through that. What are the various reasons for dishonor of check? Return unpaid due to insufficient funds. Return unpaid due to insufficiency of funds. And third condition, check is presented within the validity time, with this 3 months. Dishonor ஆச்சு because it is presented after 3 months ஒன்றும் பண்ண முடியாது. Presented within 3 months. Fourth, once returned, how do you know that check has got dishonored? பேங்க்ல போய் போடுவீங்க. Your collecting banker will intimate you the payee, உங்க செக் திருப்பி வந்துருச்சுங்க. ஷோயப் அக்தர் மாரி பவுன்சர் மாரி திருப்பியும் பின்னாடி வந்துருச்சுங்க. You say it's a bouncer. So therefore the banker intimates you. Moment he intimates you, what is the duty on the payee? What is the duty of the payee? He shall issue a notice of dishonor. He shall issue a notice of dishonor to whom? Drawer. He shall issue a notice of dishonor to the drawer. Correct. Within 30 days. Within 30 days he has to issue a notice of dishonor. Then what is the time limit for payment? Yeah. What is the time limit for payment for drawer? Drawer has to should settle the amount within 15 days. If Royer fails to settle within 15 days, what happens? After the expiry of 15 days, what happens? Royer is deemed to have committed a criminal offence. Which means deemed to have committed a criminal offence means இது ஒரு கொலை பண்ணதுக்கு equal. Deemed to have committed a criminal offence. And as a result of which, what is the result? Result is 2 years of imprisonment plus 2 years of imprisonment or fine. 2 times of check amount. 2 times of the check amount or both. ரெண்டும் pay பண்ணலாம். Or both. The check is issued to clear the liability, return unpaid due to insufficient funds. Check is presented within the validity time. He shall issue a notice of disallowance within 30 days. Time limit for payment. Royer should settle the amount within 15 days. For the extra 15 days, Royer is deemed to have committed criminal offence. After the expiry of 15 days, within 1 month after the expiry of 15 days, payee can file a case against the Royer before court of law. Then the court of law may deem that is a criminal offence and pass an order for imprisonment for 2 years or twice the amount of check or both, whichever it goes. Fine. Types of endorsement. Blank endorsement, full endorsement, then conditional endorsement. 4 sans course endorsement. 5 sans phrase endorsement. 6 partial endorsement. Simple. I'll just quickly explain you what is these type of endorsement. If you take this diagram, it is pretty easy. Come back to this diagram. Yes. What is blank endorsement? Visualize this particular process. A the back side of the instrument, it merely puts his sign and give to C. That's a blank endorsement. C enna pannalam adha? He can transfer by mere delivery. பேர் எதுவுமே ஆர்டர் கூட எழுத வேண்டாம். Be a mere delivery, he can transfer to D with A signature. A ஓட சைன் மட்டும் தான் இருக்கு அதுல. A has not said pay C or order எதுவும் போடல. That's called blank. So blank instrument can be transferred by mere delivery. கடைசியா F க்கு வருது அந்த இன்ஸ்ட்ருமெண்ட். அதுல F எழுதுறாரு. Signature of sign of A already இருக்கு. இதுக்கு மேல F எழுதுறாரு. Pay F for order எழுதிக்கிறார். Thereby converting the blank endorsement to full endorsement, and now the instrument looks as if it is directly endorsed from A to F. And how do you convert the blank endorsement to full endorsement? Add the direction for payment above the signature of the first drawer or first endorser. Simple. Now supposing A says pay C or order, or C says pay D and puts a signature, then it becomes full endorsement. Third endorsement, conditional endorsement. See, when the instrument is originally drawn, there cannot be any condition attached to it. But when it is subsequently endorsed, there can be any condition attached to it. For example, A endorses an instrument to C, pay C or order subject to arrival of ship. So olden days is what is done. Subject to the arrival of the ship at port of Chennai. Subject to the arrival of the ship at Tuticorin port. So when the ship arrives, you pay. But then, let's say that is the condition which is existing between A and C. C endorses the instrument to D. D has nothing to do whether the ship arrived or not. Let's say D is a holder in due course. On the maturing date, he goes to B and then makes him liable. Whether or not the condition happens or not, if D is a holder in due course, that does not affect him. That is a privilege given to holder in due course. Even though the instrument is originally drawn with some condition happening, whether or not the event happens or not, D as a holder in due course will not be affected with that. You get that point? Even though the instrument is originally drawn attaching some condition or is endorsed with some condition. So two simple rules. Instrument originally drawn which has some condition is not valid, because it should be an unconditional undertaking or unconditional order. Subsequently, when there is an endorsement, there are certain conditions attached to it, it is valid. Conditional attachment. What is sans course endorsement? What is sans course? Let's say C makes a normal endorsement. C makes a normal endorsement. D makes a sans course endorsement. So he says pay E or sans course அப்படின்னு சொல்லிடுறாரு. என்ன ஆகும்? He says pay E or sans course சொல்றாரு. என்ன ஆகும்? On the maturity date, E further negotiate to F. Let's say F is a holder in due course. F goes to B for presentment. If B makes a payment, okay. If B makes a default, F can sue E. E cannot sue B. Because I have effected a sans course endorsement. I transferred the risk of non-payment. Don't turn back in case the person primary. But what is the remedy available for E? What is the remedy available for E? It doesn't mean that he cannot sue D, but he can sue B. B is anyway liable, no? I can go to the court and make him liable. I can make only B liable. Do you get the point? What is sans course? Supposing A originally makes sans course, pay C or sans course. Upon maturity, what happens? F can make E liable, E can make D liable, D can make C liable, but C cannot make A liable. C can make only B liable. That is sans course. Sans is without risk. My endorsement is without risk. Sans course endorsement. Then there's also one more endorsement called sans phrase endorsement and facultative endorsement, which we have missed out for writing. What is facultative endorsement? Facultative is waiver. See, when there is a default on the part of B, F can make E liable only by serving notice of dishonor. What is the condition for making a prior party liable? Prior party can be liable only by serving notice of dishonor. I don't serve notice of dishonor, there is no question of any liability. By serving only notice of dishonor. Very simple, straightforward. So which means EF has to serve notice of dishonor to E, E has to serve notice of dishonor to every party who wants to make the prior party liable has to serve notice of dishonor. This is the right of whom? Endorser or endorser? Endorsee. F is E is the endorsee. This is the right of endorsee against the endorser. Or rather, endorser duty is to serve the notice of dishonor to endorsee. Similarly, E has to serve notice of dishonor up to the drawer. Drawer or the endorser can never be liable unless you serve a notice of dishonor. Even in case of a dishonor of a check, payee is required to serve a notice of dishonor to the drawer within a period of 30 days. Now, F has a right to receive this. F waives this right. It becomes facultative. Pay F or order, and he further states notice of dishonor dispensed with. He waives. Facultative is waiver. Waives his right to receive notice of dishonor, which means he agrees that F, you go and present the bill to B. If he makes a default, no requirement for any notice of dishonor, anything, because it involves a cost for you. notwithstanding anything, I make a payment to you. That is facultative endorsement. That's called facultative endorsement. Done. Now let's say that the bill value is 1 lakh. F, when he serves a notice of dishonor, he can claim what amount from E? 1 lakh plus expenses. Because F has to obtain a noting charges he will incur, which is a certificate given by the notary public certifying the fact that there is a dishonor. So F can recover 1 lakh plus expenses from E. Supposing E makes a sans price endorsement, he says pay F or order, he includes the word sans price. Sans is without, price is expense. E says I am liable only without expense, which means upon dishonor F can make E liable only for 1 lakh rupees or not expenses. Expenses has to be borne only by F without expenses. That's called sans price endorsement. Partial endorsement. A endorses the instrument for 1 lakh rupees. C endorses to do only 50,000. That is actually not valid. Not valid because in India partial endorsement is not valid. You cannot tear the instrument into two and then make it for 250,000. But supposing, let's assume that the instrument is drawn for 1 lakh rupees originally, and A endorses the instrument to C for 1 lakh, C endorses the instrument to D for 1 lakh. Right. On the maturity date, D presents the bill to B. B makes a payment of 50,000. What is the value of the bill as on this date prior to making an endorsement is balance of 50,000. For this 50,000, for rupees 50,000 which represents the unpaid sum, D transfers the instrument to E, E transfers the instrument to F. This is valid. This is partial, but this is valid. But this is transferred only for an unpaid sum. Originally, when it is transferred, it is not a valid because this is an instrument cannot be a partial endorsement instrument. So, what are all the various types of endorsement? Today, I had faculty to also this. So, blank endorsement. What is blank endorsement? Merely signature, only sign. Full endorsement, order for payment is available. Conditional, subject to happening of event. Sans course without risk, which means risk is to be borne by the endorsee. Sans price without expense. It means the expense has to be borne by endorsee. That is transferee. Partial, only for part of the amount. Valid, invalid. Generally invalid, but if it is transfer part, balance amount, it is valid. Facultative, waiver of the right. For example, notice of dishonor dispensed with. Facultative endorsements. Yeah.